chair for the pledge of allegiance.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Yeah, I presume this meeting has been advertised in accordance with law?
Yes, it's been published in the home news and it's posted on the bulletin board in the city hall.
Okay, so that is our open public meetings statement.
We have roll call. Carabelle.
Yes.
Anthony Jones.
Yes.
Reverend Carrington, yes. Donna Pinkovich.
Yes.
Pinkovich. Pinkovich, okay, that's here. Father Weller.
Here, ma'am.
And Brother Jude.
Here.
Okay. So we'll start with election of chair.
Yes, that's me.
Nomination for chair of this committee, I guess, for 2017.
I think, as Bill was saying,
Usually appointed
a temporary chairman.
Okay, temporary.
So that would be the attorney and myself, who the jurors, just for the purpose of electing the chairman.
Okay.
So, does somebody want to elect me as the temporary, should somebody want to move that?
I move it.
Thank you. Somebody want a second?
Second.
Okay, all in favor?
Aye.
Any opposed?
First Republican elected here.
Yes. Probably the first Presbyterian, too.
No.
Anyway, so now that I'm the temporary chairman, I will call for nominations for the position of the chairman of the board for the year 2017. Does somebody want to make a nomination?
I nominate Reverend Carrington for this chair.
I second.
It's been regularly moved and seconded that Reverend Carrington be the chairman for the year 2017. Could we have a vote on that, please?
Aye.
Are we going to do a voice vote, or do we
Either way.
voice vote? Okay, all in favor?
Aye.
Any opposed? Seeing none, duly elected. Do we swear in the chairman here, or do we sit?
Sure.
Okay. Do we have a,
I took the Bible back.
yeah, bring it back and we'll,
I like the vice chair well at the beginning of the Bible.
do it all at once?
Yeah. I'd like to make a motion that we nominate Brother Drew.
Ah,
Do we have you're in charge now.
oh, okay, okay. So we have a nomination for Brother Jude as the vice chair. So we'll entertain it. Oh,
Do we have a second? Good. There was a nomination for Brother Jude to be vice chair for 2017. And a second. Let's see, who made the nomination? Yeah. And a second. So we need to have a vote.
so entertain the vote to nominate Brother Jude as vice chair of the committee. All in favor?
Aye.
Any opposed?
Seeing none?
Unanimous.
So, I'm going to swear in, when I swear in both the chair and vice chair. If you stand up. Yeah. And try to remember the oath as best I can, because I don't have it in front of me. Put your place your left hand flat, raise your right hand. I state your name.
I, Jude the Son,
Lauren Carrington.
Do solemnly swear.
do so.
Does solemnly swear.
Support the Constitution of the United States.
Support the Constitution of the United States.
And the Constitution of the State of New Jersey.
And the Constitution of the State of New
And I
Jersey.
will faithfully, impartially, and justly
Faithfully, partially, and justly
perform all the duties
Perform all the duties
of the office of
chair
of the Board of Ethics
Board of Ethics.
of the City of New Brunswick,
City of Brunswick.
joined West my belly,
According to the best
Best
of
of
my
my
so help me God. Congratulations. Close enough.
So, is there any old business that we need to address?
Yeah.
I would imagine so. So I will entertain a motion to, has everybody had a chance to look at the minutes? They go out with the agenda. So, entertain a motion to accept the minutes as presented with any necessary corrections.
So moved.
Second,
I second.
all in favor?
Aye.
Aye.
Any opposed? No? So minutes have been approved. And so we move on to new business. And the first item is the complaint filed by Charles Catterville against NPA Big Lola. Everyone has seen a copy of that as well. The only question I have is whether there is something within the city administration, which is why it says that there is no need for him to fill out, to do the ethics.
Well, that's a decision that, that's, I guess, a legal issue that we'll have to deal with. I think procedurally, according to your policies and regulations, the proper procedure for all three of these complaints is to refer them to a two-person subcommittee
Okay,
who will then review the allegations and report back within 30 days
okay,
to the full board.
okay.
And the board has an executive session, makes a decision whether to proceed with the matter or to dismiss it at that point.
Okay,
And then if they decide to proceed, then they'll probably schedule some sort of hearing. You've got three different matters here. We're a little bit behind on the timetable, which is understandable because the board's attorney is one of the people that was subject of a complaint, so that left you a little bit at sea, and then of course you've got two new members. But I think the proper procedure at this point would be to appoint a subcommittee of two people to study this, and then they come back and make essentially a recommendation to the full board as to whether to proceed with the matter or to dismiss it. And it could be the same two people for each of the matters, or it could be two different people for each of the three complaints. Not sure how you want to do that. And whoever is on the subcommittee would presumably be advised by myself as a special counsel. The matter of the attorney, Mr. Did I say Vignola? Did I say that right?
Vignola.
That may be more of a legal question than a factual issue, because I guess it's not contested that you didn't file the piece of paper. The question is whether you're required to under the law. So that may be more of a legal issue. The other two would be more of a mixed fact and legal issue. And then I note that apparently just recently there was an amended complaint filed for, is it all three or just two of them?
Two.
Two. There was an amended complaint filed in the matter of Mr. Beer and Andrea Ito White. So that will be taken under consideration. I think under your rules, supposed to report back within 30 days. It says 30 days of the filing of the complaint. We just got amended complaints on two of them. Probably realistically, since we've got 3 different matters, probably 30 days would be a realistic time frame from today. Now, as far as the exact date, you'll have to work that out with your members. I don't know if you have, want to do that today or have everybody back to you. But we will need to schedule another meeting in roughly 30 days. At that time, we will go into executive session and the subcommittee or committees will discuss with the full board what their recommendation is on these matters. So, not sure that, it appears that I saw some paperwork in the file that the 3 individuals were notified by the city clerk of the allegations against them. Technically, under your rules, you don't have to do that until you had that preliminary review, but I guess they decided to go ahead and send it out ahead of time. And so I don't see anything wrong with that. And I guess they'll probably send them copies of the amended complaints. So we will, they're aware of the details of it. They're not required to file an answer yet, but they will have the opportunity to file an answer. They could, I suppose, file one, but they don't have to file one until you make a decision as to whether you're going to proceed with this matter or dismiss it. So at this point, I think the appropriate thing would be to set up a subcommittee for either 3 separate subcommittees or 1 subcommittee, but your rules prescribe that the subcommittee is of 2 people. So you've got 6, you could say 2, 2, 2, if you want to do it that way. Or you could give all 3 to 2 people. It's up to you how you want to do that. And then need to schedule another meeting in roughly 30 days.
Okay.
So,
All right.
other than that, I don't know if we want to get into the details of it because,
We can leave that to the subcommittee.
yeah, the subcommittee's going to investigate all that and come back and you're going to discuss it in executive session according to your rules, procedures, and then, so you don't want to say anything that might be prejudicial at this point, you know, premature.
Okay.
So, does anybody have any thoughts about how you want to handle this as far as subcommittees? 2-person subcommittees, you want to have a different subcommittee for each allegation, each complaint, or do you want to have 1 subcommittee that handles all 3 of them?
I'm thinking if anything to separate legal willows from the other 2, maybe have a subcommittee look at beer and Edo White, and then another subcommittee look at legal willows, since they're 2 kind of different
It
issues.
probably makes sense because we have hearings, we're going to have separate hearings too, so we want to mix them up and confuse things any more than necessary.
And if they're not interrelated, I mean, then probably they should be done separately.
Absolutely, yeah. So,
Or are they interrelated?
I don't think
didn't
so.
see that
I don't
when I
see
read it.
any, I don't
So
see
3
that.
separate complaints?
Yeah. The one involving the attorney is a little unique, that's almost,
Yeah, that was, I was thinking to separate that one out, and then.
yeah. But even the other 2, I think, are separate,
Okay.
separate issues. Yeah.
All right, so we need to split it up amongst the 6 of us.
I'm doing it the way we are.
That's fine.
So who would like to handle the matter with the attorney?
Want to do that one?
Sure.
Want to do that one?
So that would be Anthony and Don. Okay. say that, Clara?
Clarabelle.
Clarabelle. I know that name from somewhere, but I wasn't going to say that. You have to be a certain age to remember it.
Yes.
And Brother Junior. And then the matter of Andrea Ito White, and would be Reverend Lauren.
Peter, I think you ought to say out loud, because it's not really.
Oh, I'm sorry. Yeah, that the matter of Andrea Ito White would be Reverend Lauren, Carrington, and Father Francis Varela. And the matter of Mr. Beer is Clarabelle,
Yes.
Barber, and Father Jude Soda. And the matter of Anthony Vignolo is Anthony Jones and Donna
In Cavendish.
Pincado.
If I may ask, once this is investigated, it is investigated by us, is it just to proceed or to dismiss, or is there something else there?
It's basically a preliminary review, and you will come back, and there'll be an executive session here in roughly 30 days, and a discussion in executive as to whether the board should proceed with any or all of the matters. Take it from there.
Sir.
Peter, based on past experience, I think it'd be well to get 2 dates, because of the 3, maybe one of them at least is going to have a hearing date, and it's hard to get these folks together. I know Reverend Harrington's going to school, so you probably ought to get 2 dates. The first one to report back to the subcommittee, and the second to stand by in case a hearing is necessary.
Okay. You want to try to do that tonight? You think that's,
I think you should while you're here.
okay.
Okay.
Everybody want to look at their ability?
Are we looking at Mondays? Chair?
Yeah, fortunately, yes.
Well, you tell us when you're available, and then we see.
No, Mondays are good.
Monday's probably good,
That's
yeah.
good, that's good. I mean, they're open. So we're looking at in 4 weeks from now, basically?
Well, yeah, it would be
Let's give us time to reach the
17th.
committee, right?
either the 17th or the 24th. It's roughly 30 days, yeah. So 17th, how does that work for people?
I don't know if everybody is going to day after Easter.
It's Monday, Tuesday.
Yeah.
Is that a little kind of rough?
Yeah, 24th would be better. 24th, I'm on retreat, so.
Oh, okay. It's always a problem with something. How about
Should we take us into April 1st?
May 1st week?
Yeah, May 1st,
May
yes.
1st? How's May 1st work?
I'm not going to be available that day.
Okay.
I'll be out of
We're
town.
probably not going to be able to find any
Sure.
when somebody doesn't have an issue.
It would be 5:30, it's my first night away. Is the 17th good for everybody else? I'm sorry, the 24th?
Yeah, that's it. I think, yeah, that, but that's the same.
Or any other day during the week, or is it just on Monday we can do?
Yeah, I don't know what it is. Unless we make, I'm one out.
Okay.
Monday was pretty good for me, actually.
Okay, so April 24th is looking good.
Okay.
You can probably communicate your feelings
Yes, I'm trying to.
through the other
Get there,
one.
right.
Yeah.
Before then.
So that would be, April 24th would be
First date.
the first date, and then a possible date for further disposition. Let's see, let's specify this.
You have dates, phone numbers for all the members. If not, I'll send it to the clerk, send it out to you.
Yeah,
Yeah.
that would be good.
That would be very good. Well, it's a little bit, the procedure is, once you make a determination to proceed with the matter, then at that point, the people that are accused have the right to file a written answer or information within 30 days. So it may be stretching it to try to set a date at this point, because you're going to wait to see what they say, and then probably set a hearing. So I think we probably should just stick with that date at this time, and then we'll see where we go from there. Unfortunately, these things do not happen quickly,
No, we've been through it, so we don't.
unless someone comes forth and wants to make a proposal of some kind, But, all right, so I think that's probably as far as we can really go tonight procedurally. Does anybody have any questions about the procedure? You have your code, and then you have a separate document that's called Rules of Specific Standard Operating Procedures of the New Brunswick Ethics Board. Standard Operating Procedures, and that's what kind of spells out the way this is supposed to be done.
Peter, would you give your card to everybody, and if you don't have it with you, I'll give it mine, and we'll pass it along.
Yeah.
You have cards with you?
I just have another one. I gave one to the court reporter.
But if you just send us everybody's phone number on one page, that's fine. If you send everyone, you're going to send phone numbers, include his information with what you send out to us. And then we'll have it all on one piece of paper.
So, yeah, once you make a determination if you're going to proceed with these, then the people have 30 days to proceed, to submit whatever they want to say, and they can ask for an additional 30 days if they feel it's necessary. So, and then upon that, then we'll, the board will decide if it needs to call witnesses or anything of that side, and set the matter then for the hearing. So, okay. Are there any other questions or procedural issues at this time? Again, I think it would be premature to comment on any of the legal issues or factual issues at this point. So, and we will make sure that the people in question have received copies of the amended, there were 2 amended complaints filed with the city, so we will have those, since they also already received the original, so we'll see if they get the amended complaints. And I think that's it, unless you can think of anything else. There's a gentleman out there who's raising his hand.
Is there any further discussion on these 3 items? So then we'll open the floor to public comment.
Good evening, members of the board. I want to welcome both the new members and wish you luck. Thank you for your service. My name is Charles Cratoville, Kratovil, and I'm the complainant in these 3 matters, and some of the board members know me by now. I do want to thank you for bringing in a special counsel who seems to know exactly how this type of thing should be handled, and is doing what seems to be a very fair job. I do want to provide some explanation for why I filed the complaint against Mr. Vignolo, and I actually do have a bit of an update. It's not an amended complaint or anything, it's just actually a change in law that I want to make the board aware of if you were not already. So I'm not an ethicist or a lawyer or anything like that. I'm a journalist, run a newspaper, and I've been learning about the local government ethics law over my time doing this. I'm, again, not an expert on it, but I do want to draw your attention to the City Code of Ethics 2.32.080, Section A, states that city officers and housing inspectors, as defined in an earlier part of the ordinance, shall annually file a financial disclosure statement with the county clerk. And, I believe that definition, city officer, includes, first of all, everyone on this board. And if you didn't know, you have to file a financial disclosure statement yourself within 30 days of your appointment to comply with the law. But also your attorney, not the special counsel who's here today, but your regular primary attorney of record must file a financial disclosure statement under the law, and that citation would be under the local government ethics law, which is parallel to the city code of ethics. It's basically the same thing, more or less. It's NJSA 40A:9-22.3 would be the definitions part. And among the definitions are local government agency, which is, quote, any agency, board, governing body, ... which performs functions other than of a purely advisory nature and shall not include a school board.
Shall not include?
Shall not include a school board. So I think it's undisputed that this board does perform functions other than of a purely advisory nature and therefore is a local government agency under the local government ethics law. Draw your attention to definition G would be local government officer. And this definition is a little more complicated, but I'll read it to you.
Slowly.
Sure. Any person, whether compensated or not, whether part-time or full-time, so basically any person, who is either 1, elected, 2, serving on a local government agency with authority to enact ordinances or approve development applications or grant variances. 3 would be a member of an authority, independent authority, and 4 would be, and this is the one that matters, who is a managerial executive / confidential, managerial executive or confidential employee under Section 3 of the New Jersey Employer-Employee Relations Act, which, if you go to look at that, it has nothing to do with ethics, but the law uses this as the standard for who is deemed a managerial executive and therefore a local government officer and therefore subject to the financial disclosure requirements. And so if you look at that old law, it's actually from 1941. Definition F defines managerial executives for the purpose of local government as, quote, persons who formulate management policies and practices and person who are charged with the responsibility of directing the effectuation of such management policies and practices. And I won't bother you with the definition about confidential employees because that doesn't apply here. But managerial executives, you just heard the definition, it's a little vague. And in New Jersey, we've got 566 towns, lots of different job titles, and sometimes whether or not folks are being required to file has varied under this law. So for specifically that reason, a wise citizen of the state of New Jersey proposed a rule, an actual rule for the administrative code that was actually adopted on March the 6th. So I have copies of this new rule. It's NJAC 5:35-2. And just have a bunch of copies here. If you'd be so kind as to just take one and pass it on there. 4 pages each. So I learned a lot about the rulemaking process and would like to draw your attention to some of the comments that came up in the rulemaking process. For the record, this rule was proposed on September 6th. You'll see here at the top it says it was adopted January 31st, the same date it was filed with non-substantial changes, and then it became effective on March the 6th, so not long ago. But again, the intent was to clarify the existing framework of who's supposed to be a managerial executive and who's actually required to abide by this disclosure requirement under the law. So the first comment that I want to draw your attention to would be Kathy Reese, the Warren Township Clerk. It's on the second page, sort of the second column to the right. Ms. Kathy Reese, Warren Township Clerk, asks for a definition of independent local government agency. And it should be noted that the word independent has since been removed from the rule to make it crystal clear that it's the same thing as local government agency. And the response to Ms. Reese is crystal clear that it says, the phrase refers to an attorney serving a local government agency as defined in Local Government Ethics Law, Section 3E, Definition E. So it's the same law, the same citation that I started out with there. And just to be clear, this is a local government agency. I don't think there's any dispute about it. The next person to comment is Mr. John Reinhardt. He's the administrator.
Mr. John.
Reinhardt. And he's the administrator and CFO of a town called Wharton Borough. And he asked whether independent local agency attorney encompasses all attorneys or ones who are directly employed by the government. And this is an important issue because many attorneys for government bodies represent the attorney or represent the board through their law firm rather than a direct contract with the lawyer. And so this is an important question that affects whether a lot of people have to file. And the response is very clear. Paragraph A, 12, and 14 of the adopted new rule will require the attorney who is appointed to represent the local government agency, regardless of whether they are direct employees or contracted professionals, to file a financial disclosure statement along with any other attorney in the same firm as those named appointments who regularly provide professional services to the local government entity. And as if it wasn't enough, they say it again, right? In the next little bit, it says, regardless of whether or not a local government agency attorney is a direct employee, said attorney is considered a managerial executive by virtue of their high level of authority and independent judgment that directly affects the policies and purposes of an agency. So folks are asking these questions, they're getting clear answers that yes, attorneys for local government agencies like this one need to file. And one last comment I want to draw your attention to is the very first one from Jessica Larney, Assistant Municipal Clerk and Deputy Registrar for BRIC. And basically she asks about a variety of the positions and which ones are required to file. But it does get into this scenario of if an attorney is hired through a firm. And it says, quote, a typical scenario is one where a partner in a law firm is appointed to serve as municipal attorney, but the account is assigned to an associate who attends meetings, takes phone calls, provides legal opinions, and performs other law-related services for the client. Here, both the municipal attorney and the associate performing much of the legal work would be considered a municipal attorney under paragraph A12, and thus are required to file a financial disclosure statement. Other attorneys within that same law firm who provide little or no services to the municipality would not be required to send to file. So there's two clear standards there. One is that you're performing much of the legal work, then you've got to file. If you're providing little or no services, then you don't have to file. I think it's safe to say, as far as your attorneys in 2016, Mr. Vignola did all of the work, or almost all of the work. It was apparent from the meetings I attended. And I do want to just encourage the subcommittee that's going to be looking at that particular complaint to pick up the phone and contact the local finance board. I've been doing that with regard to this specific situation, and they've made it clear to me that their interpretation of this law is that ethics board attorneys must file financial disclosure forms, and they say that, generally, if the board members have to file, so does their attorney. And that, I said, wow, that makes sense. And so I would encourage you to pick up the phone and contact the local finance board for guidance. I can't promise what they'll say or how much guidance they'll be able to give you, but that has given me some guidance that this is a valid and true complaint, and that it does indeed set a bad example if your attorney is not going to comply with the financial disclosure requirements. That's all I wanted to talk about regarding the complaints. I wanted to just make you guys aware of that new rule that is in effect as of now. and encourage you to reach out to the local finance board as I did to get some answers. I will just close with some constructive suggestions. I'm so happy that the board is having a meeting and is back in action, so to speak. So one suggestion for how this board could make the public more aware and more engaged and involved with the work you do would be to create a website or a page on the city government website. Some other ethics boards do that, and that gives people a way to find you online, so that when people look up New Brunswick Ethics Board, maybe New Brunswick Today isn't the first thing that comes up, but maybe the official city ethics board page comes up and can explain to people in simple terms where to file a complaint, how that works, because I think it is kind of not apparent. Secondly, you could get a telephone number, an email address, P.O. box, those types of things to have those avenues for folks to contact you, so that it's not hard to figure out how to file a complaint. And I do think that the city would benefit from immediate ethics training on the basics of financial disclosure statements. We are getting to that time of year, the deadline being April 30th for this year's forms. And especially with the nuances of this new rule, it may affect certain positions. For instance, I believe municipal prosecutors do have to file, but public defenders don't. So these types of nuances could be explained in an ethics training that could be hosted in a room like this, and the folks who have to file can get the accurate information. That's something that I know other town ethics boards have done in the past, and this would be, I think, a logical thing for the board to consider as a way of limiting complaints or preventing violations from happening before they actually get to this point. And the last thing I do want to urge you to immediately hire new counsel outside of the Boris firm and terminate the relationship with them. Again, as I said, Mr. Vignolo is required to file under this law, and he has not, and I don't think the board can continue with him or any other lawyer at that firm representing them as a result of that. And so I'd encourage you to secure new counsel outside of that firm, and it looks like you're already moving ahead with everything else I would want you to do, and I'm thankful and grateful that you're giving my complaints a full and fair hearing. Thank you.
Yes,
I just wanted to say that I talked to the city clerk a day or so ago, and he had not gotten papers in from Trenton relative to filing this year. So notwithstanding what Mr. Cradaville has said, the deadline for filing has not yet passed, and is not going to pass real quick, but the clerk will be in touch with you all as soon as the papers come in.
Yeah, my name is Nathaniel Williams.
Your last name, sir?
Wait. Back in 2012, I filed an ethics complaint on some attorneys on Florida Department of Court and on perjury. On Florida Department of Court and on perjury. Okay, 3 of y'all attorneys are within here, like the city attorney, assistant attorney, and the assistant attorney and prosecutor. Now I want to resubmit my complaint with more evidence proving that it was Florida Department of Court. So I would need another ethics complaint form for y'all next meeting. I'm not gonna have it already prepared because I got it prepared already. So when y'all do come at your next meeting, I know y'all not gonna be able to go over it, but y'all will see that it is Florida Department of Court. And I am with the Innocent Project program that's going on around the world right now, where people are being falsely convicted of a crime we never committed, and it's through Florida Department of Court and perjury. So that's what I have right now, but I would like to have another ethics complaint if I could resubmit it.
Well, you of course have the right to file a complaint at any time. And I don't know what the 2012 complaint said or contained, but to the extent that that may have been adjudicated by the board at that time, it may be, or some of it may be raised judicata in the sense that it was decided you can't reopen something again. But if it's something different, and as compromise.
Yes, it is.
And I can be considered.
It
You
is.
have- Just have to, the board can't comment obviously on something like this at this
Right.
point.
I understand, but I would like to resubmit it because every last one of them, either they sit on the Attorney General Board, they sit on the malpractice board, all of them sit on the same board, even this board. He sits on this board giving y'all advice, and he's one of them that I'm filing a complaint against.
Well, we don't have anything in front of us right now, so we can't
So where-
comment.
Where can I get it?
I don't know that there's an exact form that you have to use. I think it's just a letter stating what your complaint is.
So I have to have 8 copies?
I think 1 copy is fine, that you would submit to the board, and that would go to the,
The one in Edison?
There's a procedure, it's set forth in the city's ethics procedures and in the code. So you have to look at that.
I
The
did.
clerk will help you, give you the,
I did, I went over here, Florida Foreign Court, there's no statute of limitation. And clerk advised, she said she couldn't give me advice, but she allowed me to go to the law library, and I did my own investigation. Okay, now I'm ready to submit my,
I think that would be submitted to the clerk's office.
and New Brunswick.
New
But
Brunswick
they've
City.
had that since
So
2012.
what did you do the last time?
The last time I submitted my complaint to the clerks.
Okay.
Mr. Hamilton and my attorney supposed to have a private meeting. My attorney said Mr. Hamilton would never return the call. So now I'm going to resubmit it, because I still have the same attorney. And I want to submit it with more evidence proving that never took place.
What I mean, did you submit forms the last time? And what was the procedure? Did you submit forms? or-
Yeah, I submit forms, and we supposed to came, they called me out in the hallway, and we supposed to came to the closing. They said, Tom, the third Larkin said, have Hamilton contact my attorney, and they were going to sit down at the table and come to, a conclusion. But my attorney said every time he called Mr. Hamilton, he would never respond back to his call.
Now, can you re-engage your attorney at this point?
Yes, I do, but I'm about ready to file one on him because I think whatever he said to him, he scared him. And then when I ready to file for malpractice, Shamry's brother runs that. And them are the attorneys I'm going at. So it's like I keep running into a brick wall.
I think the best thing for you to do is to write out your complaint, submit that to the City of New Brunswick
Okay,
Clerk's
okay.
office, and then because
Because they already got it, it's already stamped.
Gotta be sworn to, Reverend.
and a sworn statement. It has to be a
Okay.
sworn statement. But if it would have to be something, not the one that you submitted in 2012 that we've already addressed.
We do.
This would have to be a whole new document.
Oh, yeah, okay, that's no problem.
Okay? And no, with whatever is different from, that is different from what you submitted last.
Oh, absolutely, absolutely. Thank you.
Is there any other public comment?